Good evening, everyone. Welcome to July 17th, 2025 Board of Adjustment meeting. Judge, can you please call, roll call, please?
Yes, sir. Mr. Gallo?
Here.
Mr. Carter? Mr. Carter?
Here.
Miss Denny?
Here.
Miss Hudson?
Here.
Mr. Cusick?
Here.
Thank you. That is 5 present.
Thank you. With 5 present, we do have a quorum. Introduction of staff, please.
Good evening, everyone. My name is Jesse Lindenberg. I'll be presiding as the hearing officer tonight. To my left is Mark Kennedy. He is our IT specialist. And down on the end, we have Fred Townsend, the attorney for the board.
Thank you. At this time, everyone please stand for the Pledge of Allegiance. Any additions or alterations to tonight's agenda?
No, sir.
Thank you. Public hearing introduction, please.
Good evening, everyone. My name is Jesse Lindenberg, and I will preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of these applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to the other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called, and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from all of those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471 to learn of the board's ruling. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on June 29, 2025 in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you. At this time, we'll have a statement by counsel. Mr. Townsend?
Thank you, sir. The standards for the granting of area variances were set forth by the Delaware Supreme Court in a case known as Board of Adjustment versus Quick Check Realty. For area variances, the board considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. And to make that determination, the board must weigh the following 4 factors. First, the nature of the zoning district where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And lastly, whether failure to remove the restriction would create exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is satisfied only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. Note that the inability to improve one's business or stay competitive as a result of area variances may qualify as a legitimate exceptional practical difficulty. And it's here where the board considers whether the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board's not permitted to consider factors other than the four listed, so those speaking both in support of and in opposition to applications are urged to present only information bearing directly on those four factors, which restated are: 1, the zoning district; 2, the character of the immediate vicinity; 3, the effect on neighboring properties; and 4, whether the applicant faces exceptional practical difficulties of ownership. In particular, presenters are instructed to exclude from their presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is not authorized to resolve those disputes. Please, as presenters, limit your remarks to those the board can decide. That concludes my statement. Thank you.
Thank you. At this time, we'll begin the public hearing, starting with application 82516.
Thank you. Application A2516 for Smyrna Rentals LLC is seeking a variance from the rear setback of 25 feet to allow for the construction of a commercial building. The property is located on the west side of South DuPont Boulevard, west of Twin Willows Road, east of Smyrna. Levy Court District is the first. Zoning district is BG. Here is the plot plan showing the proposed building as 10 feet from the rear. In the blue is the setbacks for the property, 15-foot sides and the 25-foot rear. This is just a staff exhibit to go along with the recommendation, showing that there is room for the building inside of the setbacks. This is looking at the property, up the road, back down the road, across the way from the property, on the side where the existing building that will be removed is, further in the back of the property, also from the back of the property, kind of looking forward, the aerial, and further out. So, sir, if you're here to represent the application, you want to come up to one of the podiums, please state your name and address and allow our attorney to swear you in.
My name is Dana Watte, address 812 Fayette Road, Smyrna, Delaware.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. So can you, okay, so you can see in Exhibit B where the existing garage is right behind the building, and the couple parking spaces directly to the left are very difficult to get into.
You can also point on that screen next to you if you'd like to, and it will pull up an arrow.
Do I do it with my pen, my finger, or my finger? Okay, so this here is where a couple existing parking spaces are. By building the extra building that we want to build, even by taking down the garage, it would open this up. But it wouldn't give us any additional parking here because that would just go back further because this is the entrance to the back of the building. We're asking for the variance because it would allow us to expand the parking lot more than anything else, as well as not have a lot of unused space. As you could see in some of the pictures that went further, right now some of the staff actually, when we have a lot of parking, are parking behind the existing building. We're trying to make it so we don't park behind the building, but actually on the parking lot itself. This side of where the new building might be placed has to be reserved for water retention. So that wouldn't give us any space around here unless we open this all up as parking lot. By not giving us the variance at all, what I'm saying is that we would not really expand the parking spaces beyond what they are right now. And like I said, we're parking behind the building right now when we are busy or have a lot of people, especially during tax season, we are a tax office, that we would actually lose parking. The new building, about 2/3 of it is just going to be garage, replacing the garage that's there. And then to the right side, we're hoping to put in a conference area and possibly a future office and bathroom in the future. Right now, to the left, facing the building is Verizon, used to be Delaware Phone Company, and it's an entirely wooded area. And then to the left of that is a construction company, which does have buildings all the way back, but I know they've been there for a long time. Directly behind us, we have a fenced-in area on all three sides in the back, is the Garrison Lake Golf Course. So if you see right here, we actually have a fence right now right here. So the golf course actually is right here. And this is the telephone company, this is the construction company next to us, and this is a daycare. That's all I got. We're really asking for the variance so we can expand the parking lot and have enough room to kind of move around. By having the building too close up here, we're going to limit the area that we have here, and everything behind it we won't even be able to get to without walking around the building.
Thank you. I just have one quick question. Is there a parking requirement based on your site? Do we need to expand the parking, or?
I believe from what I heard from the architect, we have enough parking for right now, but we would have to add, I don't know what he said, between 2 and 4 spaces. By pushing the variance back, it would give us that, because we could actually expand the parking lot and have parking all the way in front of the building. And you can, again, if you went back to that one picture, you could see a car kind of hidden back there at one point. Yeah, go back one. This car, I mean, it's very difficult for them to even park. They usually have to pull up to the back and then back in. You can't just pull into these last 2 spaces. This is a handicap space, but again, when these are full, you're pulling straight out where these vehicles are trying to back out. If we got rid of this in the new building, we could expand the parking lot kind of to almost the rear of where this truck is, all the way across. So it would give us all the parking that we need for the size of the building.
Any other questions, comments?
I have a question for the staff. On Exhibit B, looking at that drawing, is the property currently legal, dimensionally non-conforming?
The existing building, yes.
So if we granted the variance, we would be increasing the amount of non-conformity, correct?
It would increase the number of non-conforming structures technically, but because they have a variance, it wouldn't be considered non-conforming in that respect. So like, it wouldn't comply with what the requirements are, but the variance would make it legal, so we wouldn't consider it non-conforming in the same way that we would something that is legal non-conforming.
Okay, so I have a question for the staff. So if that building goes away, it's now grandfathered in. If it goes away, it can't be replaced without the variance, especially to what he's trying to do, because it's all if they totally take away the existing non-conforming use, then they have to start over. It's like a new clean slate.
So the building that they're proposing to remove is the small one here, that small garage. The main building, yes, if that were to be willfully demolished, then we would not allow them to replace it in the same place. It would have to conform with the current setback requirements.
Thank you.
Mm-hmm.
May I? So, response to one of the questions, or Mr. Gallo's question, the concern about aggravating the nonconformity would apply better if they were trying to enlarge the existing building along the front of the property in an area where they're not permitted to do that. So I think that's where that concept comes into play. They are looking to add another non-conforming structure, but they're not aggravating an existing non-conforming structure. So there is a difference. But that was a good question, but I thought I'd like to speak to it. Also a question for the applicant. The difficulty you're having in part is based on the size of the structure you'd like to build, and there's not much in the record about what you intend to do with that, why it needs to be the dimensions that it is. Could you add some information for the consideration of the board?
Yep, we have a current it's about 20 by 25 garage, and it's a block building, and it is in disrepair. It needs to come down. So that's what kind of got us started on this, and we looked at it from a point of, okay, if we do a back door to front door, covered walkway, could we do a conference room? We're a CPA firm, small CPA firm. We really don't have any meeting space or anything like that. So that was the next idea of the right side of the building. We could actually build it out to be a conference room and a second bathroom. We only have one bathroom.
And the other portion of the building would be devoted to storage of some sort, or?
No, I mean, it's a 100-year-old farmhouse right now. The current building. Oh, you mean the new building?
Yeah, the new building.
Oh, I'm sorry.
The new building, the
Yes.
dimensions of it are what, 52
so the right-
by 46? Why do you need 52 by 46? What are you going to do with all that space?
Well, we would have a 2-bay garage on the left-hand side, which would be the biggest portion of it. And then the right side, we want to do a conference area, a storage area, the IT room, take it out of the main building, and a bathroom. And possible in the future to put an office in if we wanted to.
And you have a demand for additional office space?
We do. So we wanted to do this instead of trying to buy a new property. And when we started this journey with Mountain Consulting, it's been almost 2 years. And we were looking for property at that time, but it made sense to build on here. But now, of course, there's not a lot of inventory for extra office space either out there, and we'd rather keep everybody housed in the same location. So this was a good option.
So when I first opened this packet, it's filed under Smyrna Rentals LLC.
That's who owns the real estate.
But you're saying it's an accounting office. So what is it? Oh, that's who owns the real estate. You're going to buy it?
We own the property,
Okay.
and the firm rents from the property. It's an actual small CPA firm. There's 6 of us right now. But myself and another relative actually own the property. We bought the property with the intention of opening a small firm.
Okay, so essentially what we're looking at is a CPA firm, not really, like when, it kind of, it seemed like it was some type of a rental business, but it's not. It's literally
No.
a CP, it's an
Yes.
accounting office.
Yes,
Okay,
that's just the name of who owns the property, and it's the only property held by that entity.
thank you.
Yes, ma'am.
Did we discover trying to rotate that building and put it right behind your office now?
They looked at moving it a couple different ways. If you look at this area right here, you see there's a big holly tree right here, and the plumbing goes right up against here, which is away from here. So we can't move it very far because of the plumbing. We'd have to take this tree down. And we're also trying not to encroach on this property. It is a daycare, and their yard back here is where all the kids are. So that's why we're trying to put it back and over as far as we can. And if you look at the pictures, the dimensions look nice here on the drawing, but there's really not a lot of space if you look at it next to the neighbors. I mean, my pickup truck probably goes halfway back into the yard when you're looking at the one picture.
So we're 52 feet lengthwise and 46 feet depth, right?
Yes.
So I guess to Mr. Townsend's point, so is 46 feet depth required?
Not necessarily. We did that so we could have, we kind of measured it so we would, and I have another picture I did not bring with me that has it broken out by a conference area here and then a IT room here, a bathroom in the middle, a storage area here, and then a door going into the garage. And we actually have it drawn out from the bathroom, little hallway, conference room. So that's how we came up with the 46 feet.
And this is a,
The 52 wide is we did the garage and then having, I think, 20 feet for this piece of it. So it was wide enough for a standard conference room.
and this is a pole building?
Yes.
Have you signed any contracts with the pole building at all, or are we locked in there? And
Yes. Delmarva Pole Buildings.
any deposits been made yet, or any financial?
Yes, we did. And again, when we started this process about 2 years ago, Mountain Consulting was going to take care of all of the permitting and all this other stuff. And a lot of things have changed since then, and they are not responding to us. And we've had several meetings between the builder and the architect and designer.
So this is no longer, I mean, this isn't going to be a residential use in any way,
Now,
but you still need a garage.
actually, the barn that we have right now is pretty full with equipment. I do use it for some personal items, but we have, a tractor and lawn stuff. I do have a wood splitter in there and things of that nature.
So it's really, you're not using it for cars as much as you're using it for storage, for equipment, for maintaining the property, things like that.
Yes, that's what it is right now.
Thank you.
Any other questions or comments?
And the current building was residential, I know years ago, was even rented as residential, I think 2 people before us. But it's not set up for bedrooms or anything else. It is built out as an office building.
Would you be willing to make an adjustment on the size of the building to reduce the amount of encroachment on the rear line?
What do you mean?
In
Sorry.
other words, the rear setback is supposed to be 25 feet, and you're looking for a variance so that it's 15 feet less than that. I mean, would you be able to adjust that depth to make it a little less of a variance?
I'm sure we could. I was trying to maximize the parking area as well as minimize the unused area in the back, because we no longer are going to be able to access that except for to cut the grass. That was my purpose there. Would we be, the only thing we'd be encroaching on by being further back is the golf course itself. And that's why I came for the variance as well. I did not think it would affect the golf course.
And that's that backyard is pretty much wooded, that property line.
This is all, there's trees right up against our fence here, but it is Garrison Lake Golf Course.
Right, yep.
Our property line beyond the fence goes back about 2 feet maybe. And then to the left here, like I said, this is all wooded before he gets to the construction company. Yeah, so this is all wooded here. We can't even see through it this time of year. And you can see how much is here along the golf course, but it is the public golf course.
Ingress and egress is off of 13? I mean, obviously.
Yeah,
Okay.
that's the only in and
So,
out is
and
13.
it's- Okay.
And we did have DelDOT come out as well, County Conservation, to look at, is this feasible if we can get the setback to get everything else in place?
And DelDOT was comfortable with it?
Yep.
As it
They
is.
showed us where we were going to have to put stop signs, and we're going to have to put a little sidewalk on each side. There's a dip right here, I think, that would have to be filled in so they could do the sidewalks, and then we would have to reserve some space here to the left for the watershed.
How will the new building allow you to be more competitive as far as your business?
So I know you haven't been in the building, but the building, when you walk in the front door, there's a reception area, and then there's offices. And I mean, this was an old house. It's a very nice kitchen in there. And then there's a little seating area that steps down because it's a very old house. And that used to be an outside porch. But there's no privacy in the building. The only private office suite is mine, which is on the second floor. So anybody disabled, I can't really take upstairs. And there's no private meeting place downstairs for corporations or families or estates, things of that nature. This would allow us to have a conference area further apart that we could do meetings. We could do, I mean, we're a little bit excited about it, to do training for the staff, where we could have, you know, big screens instead of just computer screens, meet with companies, meet with folks on the first floor that we need to. And during tax season even, it would give us another place to actually process private information.
Thank you.
Yeah, thank you. And right now, to that point, we're maxed out. If we wanted to hire somebody else, we have no place to put them. And during tax season, we would like to hire another processor or administrative person just to do that function I was just talking about.
Just to be clear with the testimony, so Kent Conservation has been there, they're comfortable with the amount of with the drainage as it exists and
Yep.
how it should remain with once this building takes up that amount of.
They walked it with us and they showed us exactly what we had to do because of the existing parking lot. Where the drop off is in the back, we would have to dig out this entire area and for the drainage piece itself.
Okay.
They were out there with DelDOT. We had quite a few people out just right before I put in the application.
Well, I have always, you know, wanted to consider impervious soil, but, you know, sometimes we forget what it's like when you go through these 100-year flood events and all, and it feels lately like we have been going through one for some months now. And the
can feel it.
drainage is important, but if it's good enough for Kent Conservation, that's fine.
Yeah, they would have to come out and tell us exactly how big the space would be that we would have to reserve on the left side of the building.
If it's any help, Ms. Denny, because it's commercial, it will have to come through site plan review after the variance, and we would require KCD sign off for the site plan.
Very good. Any other questions, comments? Good. Appreciate it. Thank you.
Thank you very much.
Is there anyone else present that would like to speak in favor of the application? Do we have anyone online?
We have no members from the general public online at this time.
Thank you. Is there anyone else present that would like to speak in opposition of the application? And no one online. With that, we will close the hearing for application A2516. Our next application is A2518. Anthony Ronald Jackson and Gunahal Osbe seek a variance from the condition that at least one occupant of an Echo unit must be over 62. The property is located on the west side of Burris Drive, 0.3 miles south of Long Ridge Road, west of Clayton. Levy Court District is the 6th, and zoning district is AR. Here you can see a plot plan showing the existing two-story home, accessory structures, and then the manufactured home that is used as an Echo. This is looking at the property, looking up Burris Drive, the other way. Again, looking at the property up the driveway. Another angle towards the Echo unit there. Further back on the road, looking towards the property again. The aerial and further out. So, sir, if you would like to come up, please state your name and your address and allow our attorney to swear you in.
Anthony Jackson, 308 Burris Drive, Clayton, Delaware.
Mr. Jackson, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. I'd like to start off with a photo. I know this is about property for you, but for me, this is about family. This is my mother, Ginger Brewer, 77 years old, and she is struggling, deteriorating with dementia. She has been coming to our Echo for the past 13 years during the summer as she watched my daughter and as my daughter watched over her. Her time here was a break for her husband and for my sister. This past year, we were told that her husband has been hit with lung cancer for the 3rd time now. This time, he won't be going on chemo. Understandably, her husband doesn't want her to come to Delaware this year. He also is unstable, and when he heard my mother would be signing the form for the Echo unit, he went into a raging panic and wouldn't let my sister take my mother to go get the form notarized. If her husband dies this year, my mother will need to be watched again next year to give my sisters a break. Without the Echo unit, there will be no place for her to stay with me. This is my sister Katrina Gergley. She has very many medical problems right now. She is 61 years old, and she will be 62 in just a few months. She was hoping to come and spend time with family, especially after the surgeries that she's facing. While Katrina visited me, Mom would stay with my other sister. Mom would be rotated amongst her 3 kids in order to be able to share the burden of taking care of family. I'm Anthony Jackson. My wife and I are the owners of the property in the Echo unit. I am a veteran who has served our country, and I continue to serve our community as an environmental educator for the Division of Fish and Wildlife. I bought that property because I wanted seclusion and security in my life. This whole fiasco has left me feeling insecure. It has left us asking what has happened to landowners' rights. 4 years ago, I had a triple bypass surgery on an open heart. Since then, I often go lightheaded, I often go gray, sometimes I go black. The home that we have, the farm home, is a 2-story home with only 2 bedrooms. I can get up those stairs, but by the time I get to the top of the stairs, I'm winded. Twice this year, I've already fallen down on those stairs. I talked to my doctor about the gray periods and talking about passing out, and he has encouraged me to try to stay off the stairs and try not to get in too many arguments with the wife. I know that seemed kind of funny, but when you're sitting there arguing with somebody after you've had a heart surgery and you start getting upset, you start getting gray, you start getting fuzzy. And falling down the stairs, the 2 times that it happened, would you be surprised that I was arguing with my wife when I walked back downstairs too quickly? It wasn't fun. I stayed in the living room for a month before my mother came to visit. The living room was often noisy, so I began to stay with her in the Echo unit as we kept watch of one another, and my daughter would frequently drop in to check in on us. After the surgery, my blood flow is still limited and my blood pressure is high. Twice I've fallen on the stairs. Also, with all the added tension, my wife and I have spent way too much arguing, which the doctor encourages me to avoid. Best way to avoid that was to go over and stay with my mother in the Echo unit, and so that I could keep an eye on her and she could keep an eye on me. And my daughter would come over and check on the two of us when she got home from school and when she went off to work and when she came back from her friend's house and so on. So it's nice to have a daughter that keeps an eye on you. Staying in the mobile home is the only way that I've maintained my physical and psychological health and kept our families together. Like I said, our farmhouse has only 2 bedrooms. The Echo unit was the only affordable way to host my mother, my sister, or myself. We have no intent on selling the property in the foreseeable future. Repeatedly, an accessory dwelling unit was recommended to us. According to them, a manufactured home is not a homeowner's rights. In other words, if I can't afford an accessory dwelling unit, I have no right to a mobile home, no right to take care of my family. People with money can help their families. Those who cannot afford construction don't have the right to have family help one another. My bill for the heart surgery was $76,000. That was a pretty good chunk inside of our savings. Removing our Echo unit would financially destroy my family. Just to be here this afternoon has cost me $300 just to stand before you. That's a week's groceries for me. We don't have a lot of money. We have some savings and we would like to take care of our child. As far as the property, like you've seen, there's the mobile home. Oh, yeah, there it goes. And thank you. And as you can see, there's a single wide back here. There's a single wide back here. This property over here, just past this tree line, is divided into 3 lots. Those are all single wides. I've got single wides all around me. Nobody's taking offenses to a single wide. Even if they did, take a look here. This is a tree line. The only way that you're going to see that mobile homes is if you come all the way down to the dead end and then you can see it a little bit through the trees. Elsewise, you cannot see that mobile home. I'm not offending anybody. I'm not trying to lower anybody's property values. These are all double wide mobile homes. These aren't mansions. I'm just looking for some peace with my family.
Sir, I had a question. Have you thought about just splitting your lot into 2, and then it'd be 2 different parcels?
Yes, I had, but I was told that
you wouldn't
is
need-
very unlikely. I was told that it was very difficult to do, and that was unlikely, so we ended up going for the Echo unit. And as far as the Echo unit is concerned, it was pretty easy and straightforward with my mother up until she couldn't get the signature because her husband's got cancer. And then I went and tried to include my sister, and she's a couple of months shy of 62. And then looking at myself, you know, I hope I live a while. I mean, I know that I'm not going to live to be 100, that's for sure. But I might make it the next 10 years or so. And I would like to take care of my family in the last few years that I've got.
I have a question for planning. Trying to divide that lot's just gonna create 2 non-conforming lots, correct?
So the property is actually within a subdivision. So in order to subdivide the plot, they would have to revise the subdivision. And in our code, that requires sign off from 100% of adjacent and 75% of the subdivision itself.
Thank you.
Not many people have attempted it. Those that have, usually the applications drop off. So we did have that discussion with the applicant.
I would be happy to go through with that, but it sounded as though, or I was under the impression that it's going to be a long, drawn-out process, and so it was easier to go with the Echo unit to get my mom taken care of.
So is
Thank
it
you.
currently an Echo unit?
So it was approved in 2013, I believe, for an Echo unit. We require Echo units to be renewed every year. You have to show that you still have the need present on the property. So as the applicant has explained, there's difficulty for him to obtain that signature. So then he tried to switch it to the sister, and then the sister isn't quite old enough for the Echo unit, and that's why he's here for the variance.
Got it, thank you.
And how long before your sister will reach these
December.
December? Thank you.
Is that the only issue as far as the county is concerned?
Yes, that is the only variance being requested, is that they do not currently have someone who is old enough to qualify because the sister is not old enough and because we can't get the signature from.
Well, I was
The mom.
hoping to include being considered in the Echo unit because, like I said, my sister is obese. She has serious medical problems. We'll be lucky if she makes it a few years. And so I would like to make sure that, you know, I would prefer that it was my name on the Echo unit. And then that way I could take care of my mother and my sister.
Well, whose name it is in, it doesn't affect us. It's who resides in. Is that so?
So the way that the code portion is written is that at least one occupant in the Echo unit has to be over the age of 62 and needs, let me pull up the specifics so I get the exact, but essentially needs care, cannot live independently. That's the phrasing that's in code. So the current proposal was for the sister. It would be renewed every year. So as that year happens, if we need someone else to renew it, then we can look at that year.
Question.
Yes.
So if a variance is granted, he would have to still renew this next year, right? Then he would still have to be every single year.
And not to be disrespectful, but when you get those messages in the mail that it's time for you to fill out that form again, it's almost like having somebody ask you every year, is she dead yet? Is she dead yet? Is she dead yet?
To be honest, I would have to check. As far as I know, the variance would hold that the applicant, it depends on how the motion's worded, I believe, on how we work that. I don't know, Fred, if you have any input on that at the moment.
Well, my question was going to be, like, she's from now to December away from being old enough to occupy. So essentially, the variance that we could approve this evening, if that was the choice of the members, would just, it's completely based on age. And so once she became legal in December, then it doesn't have to be renewed every year because she's old enough. But you still have to, identify that she's still the resident, the residing, or the legal.
Yes, so once she was old enough, I suppose the variance wouldn't be needed to reestablish that. Typically, variances hold with the property. I'm trying to think through what that process would look like.
You know, these are very few and far between, and when they come up, that's usually cut and dry. I mean, it's just, but I can remember, and I obviously I've been here a long time, so it could have been like 18 years ago or something, but I can remember having one of these before, and it was kind of the same issue, like, you know, when does it expire? I mean, you know, you're not going to send, like he said, you're not going to send a letter every month and saying, are they still here? But essentially, we would and actually, this is probably a question more for council, but it feels to, I can remember having this and all these little complications as we're trying to make a decision. But if we were to grant a variance until, let's say, mid-January or something, so she would have become old enough, and any paperwork or something that the county would want done is done, then again, there's no variance needed further because she's become old enough for this to be, not need a variance.
If I understand what you're saying correctly, I think it might be, again, a question that Fred might be able to weigh in on, if they can word the motion in a way that allows the sister to be the current, and then that is all that it allows, so maybe just to allow her to apply, and then the variance wouldn't apply for future?
It's like a, yeah, exactly. Thank you, Morgan. It's a conditional.
It could be a conditional use until the age, but, okay. And you said the sister's currently living in the mobile home that's on the property right now?
No, I am staying in the mobile home because, like I said, I can't make it up the stairs. I can't deal with arguing with the wife. And when my mother or my sister do come, I want to be there with them so that we can keep our eye on each other.
So your intent is to stay in the Echo unit yourself, correct?
Yes, that as well. My family always comes first. If I have to sleep in the barn, I'll sleep in the barn. But I would like to take care of my family if it's possible.
So the property of the owner cannot sign off on the Echo, I'm taking it? If they are of age, can they sign off on Echo?
Okay, take me back again, because, so, the father won't sign,
I'm not a big fan of the guy to begin with. He was a very commanding kind of guy, and she snapped to attention whenever he told her to jump.
well, again, at this point, because the who struck John of it doesn't matter to the board, but the question I'm asking is, he can't sign, won't sign, for whatever reason, not available to sign. So it would be you and the sister living in this Echo unit.
I would be living year-round. My sister would be coming whenever she could for the holidays. Like I said, she does have some surgeries coming up, and when she has the surgery, she needs help getting around, so that would be an opportunity. So she would be, she does have a home down in Florida. She does take care of my mother when she's down there.
Okay.
She's around the corner from Mom, so she's the one that usually takes care of her for the day-to-day things.
Okay, so the person who would be the, let's say, quote-unquote, full-time resident will be you alone, and you are not within the age limit that you are allowed to reside in an Echo unit.
No, I'm not. But
So that's really what this variance is about, because your sister being a snowbird here, there, taking care of this and that doesn't have anything to do with the legality of what this board is to decide.
well, it's also a matter of disability. I mean, I'm absolutely amazed that there aren't more people living in Echo units, people with autism, people with disabilities, people that are blind. I mean, what do we
And
do?
I understand that you're questioning that, but that is not up to this particular board. We have, the county has a comprehensive plan and codes.
Why do they write disability on the forms then?
Because it's what is written in it, because obviously,
If we don't mean disability, why does it say disability?
because that's what it says in the code.
The code says
And so-
disability, but then you don't include any people with disabilities until they're 62?
Sir,
I'm trying to
okay,
understand.
listen, here, this is what I'm telling you. There's a comprehensive plan, and there are codes for the county. We are here, the purpose of this body is when something comes up that is particular to a certain property that prevents the use with the code, we are charged with hearing you, finding an impractical difficulty that makes that property and that situation different so that we can, let's say, bend the rules or, in legal terms, grant a variance. You're here telling us that this is for your sister and she's going to be, old enough in December, but your sister isn't going to, what your testimony moments ago, and you can certainly tell me if I'm wrong, but my interpretation of what you said is the sister is not the handicapped, whatever you want to call it, the resident. You are to be the permanent resident. And that's, again, tell me if I'm wrong, but that's what I
I'm not,
heard when you gave your testimony.
No, I'm not
Okay,
trying
thank you.
to dodge that. I'm trying to ask honest questions because, this is something you've been doing for years. This is the first time in my life I've had to deal with this. And when I see that something is either due to age or disability, that they're, eligible for an ECHO unit, and then you say it's only age, not disability at all, I don't know how that happened.
If I may answer your
Please.
earlier question. Reading over the code currently and based on my understanding it, I don't know that there's necessarily something prohibiting him as the owner. The phrasing itself for the occupant does specify that one occupant of the principal residence and at least one occupant of the ECHO unit must be related by blood, marriage, or legal adoption and shall be limited to a son or daughter or lineal descendant, antecedent, or sibling. The ending portion of that somewhat implies that it's someone related to the property owner, not necessarily the property owner themselves. I can say that the intention of the ECHO units is to allow for temporary housing for the elderly. That's part of where the ECHO unit name comes from. I will also say that it does not use the word disability. It does specify that it is for someone over the age of 62. Sorry, pulling up the specific language here.
Frail.
At least one occupant of the ECHO unit must be over 62 and unable to live independently.
It also has here that a property owner must agree to a special condition as part of the application process before the permitting. So when you applied for the first time, that this was temporary for one person and would be removed when one person doesn't need it anymore, not to stay with
Initially, that's what the situation was. It wasn't until I had my heart surgery and was having difficulty getting up the stairs that I went and stayed with my mother.
So question for staff. So what happens to this mobile home if it's not an ECHO?
If it is not an ECHO, then it has to be removed from the property.
And so I just lose another huge chunk of money. And my family ends up, what, on the street?
unless you divide your property into two, and then that would become a separate unit.
Well, even at that, they're threatening to rip the mobile home off the property as quick as they can.
Were you the original person that applied for the original ECHO unit
Yes.
permit? And you knew it was temporary then?
Oh, I know it was until, as long as my mom was alive, and she's still alive. I would still like to take care of her.
Well, it's not necessarily just that, it's the need for it. So if your mom went to assisted living or something like that, that would end it as well. So it's not just if someone is deceased. There could be other reasons why they no longer have that unit. That unit is supposed to be a temporary situation. it's not set up to be a permanent fixture on the property.
I'm not expecting it to be forever and a day, but I would like to at least take care of my family while they're still alive.
So, okay.
So was that unit placed there for your mother
Yes,
as an Echo unit?
yes.
How long ago was that?
13 years?
But your mother is no longer residing there. She's residing with did you say sister-in-law? She's residing elsewhere.
This
is not
she's
her.
residing with her husband, who is expected to not make it through the year. So she's going to need to come back.
And we don't know when that will happen, but
Not until he drops.
so when that happens, it would be the more,
When
and
that
she's,
happens, then the mobile home will already be gone, and I'll have nothing to help her with.
Is there a reason why they both can't live in the mobile home?
It's 3 bedrooms.
No,
It's-
I'm saying your mother and her husband. Could they move back into the mobile?
Oh, he's never going to come into my home. And that's not because something I have against him. That's because he really doesn't like me. When we sat there and got into this conversation about signing up for the paperwork, he was still going on about me ripping him off because when I got into a motorcycle accident when I was 16,
Okay.
we're getting beyond.
Yeah, that's way outside of our considerations here.
He-
I
he's-
think I, and maybe others, would benefit from a little 5-minute recess. So I've got some questions that I think staff can help me with, and maybe vice versa about this. And I don't really want to close the public hearing, though, necessarily, in case there are other questions that come up from that. Can we do that?
Yep. Do I? Recess. Yeah, we're going to take a little recess.
I think you can
5-minute
just
recess.
declare.
Motion for
you can-
recess.
You can declare
Yeah,
a
kind of-
recess.
Joan Denny, I'd like to make a motion that we recess.
Second.
All in favor? Aye. All right, we'll continue with application A 25-18. You want to call roll to make sure everyone's here?
Yes, sir. Mr. Gallo?
Here.
Mr. Carter?
Here.
Ms. Hudson? Ms. Denny?
Here.
Mr. Cusick?
Here.
Thank you. That's 5 present.
All right, thank you.
Okay, if I may, just a quick question before we get started with my comments. Is there anyone else here in the audience who wishes to speak to this application? Okay, so we'll get to you before we finish up, of course. So the standards identified in the report prepared by staff, you noticed, are different for this variance than they are for the typical variance, which is an area variance. This is not a typical variance. This is characterized as a use variance, which requires the satisfaction of 4 different criteria that are related to the criteria that we apply in area variances, but are somewhat stricter. Area variances can be said to be a weighing of the harm or impact on neighboring properties against the harm to the applicant if they don't get the relief that they're seeking. Here, the showing is a little bit more onerous on the part of the applicant, who must show, number 1, that the property cannot yield a reasonable return when used for permitted purpose. 2, that the plight of the owner is due to unique circumstances. 3, the use authorized will not alter the essential character of the locality. And 4, all the uses of the land permitted under the existing zoning regulations are economically unfeasible. As far as economics are concerned, and we're not done with the public hearing yet, there's an economic hardship that's being raised that the Echo unit will be likely in need of use in the future, just not presently. Although the applicant either likes or needs to use the unit, I think the Echo regulations require that the use be on the part of an elderly parent. So I'm not sure to what extent it would be persuasive to consider the desire of the applicant to continue to use the property. As staff indicated, I'm not sure necessarily that the applicant is prohibited from occupying the property, but the fact that the applicant does or wants to occupy the Echo unit is probably not terribly persuasive on his behalf. The applicant did speak to the character of the locality and pointed out that there are a number of such dwellings in the area, and made, I think, a strong case with images that the Echo unit, if allowed to remain, will not alter the essential character of the property. The plight of the second criteria, or third, I'm going backwards, the third criteria is the plight of the owner is due to unique circumstances. So these are meant to be circumstances that aren't generally applicable to others. Those circumstances would be routine, and this gentleman's making a case that his circumstances are not routine, that due to a medical condition that his mother's spouse suffers from, she cannot occupy the Echo unit at the present time, but his representation is it's very likely that she will require use of the Echo unit in the near term. The first criteria is that the property cannot yield a reasonable return when used for a permitted purpose. So,
I'm sorry, could you please, I don't understand that phrase.
I would put that in the context of the Echo unit itself. the Echo unit is part of the property, I suppose, even though it's a temporary structure. And there's an argument being made that the usefulness of that structure will be eliminated if this relief is not granted. So that's, I think, the best I can do to pigeonhole the application into the considerations that are appropriate for you. This is not typical. This is the second use variance application I've seen, not here, but among the 3 or 4 different boards of adjustment that I represent in maybe the last 5 years. So it's understandable if it takes a little bit of extra time to work through this for the board. Do you have any questions about that?
I don't understand how it is that I drive down the street and I can see cars that have been sitting there for years and years and junk piled up years and years, and yet I have a decent looking mobile home that matches the house perfectly, and mine's a problem. Mine's the one that you got to get rid of, although I've got family that's waiting to use it. But just down the street, junk piled high and cars all over the place and parts and rusting. I don't see how the priority.
I'm not sure why it is that you were directing that concern to me, but
because there is so much pressure at destroying this mobile home.
I don't know that I was adding to the pressure to destroy the mobile home. The mobile home, as you recall, was a structure that you were permitted to place on the property under the condition that it serve as a place for your elderly, frail mother who could not be independent. And in the absence of her on the property, we have this problem. That's the problem, because the conditions under which the permit to place the mobile home there was granted no longer exist. And you're asking the board to grant you relief from what the code requires, that your elderly mother occupy the property or someone else who fits that description. So right now, you have characterized your desire to keep the mobile home on the property as, one, being contingent upon your mother's return, and two, being convenient for you. That second consideration, I don't think, I think that's a routine consideration. I think a lot of people would like to have a second dwelling unit on their property for any number of different reasons, including putting some distance between them and their spouse, maybe, as you've described. But that would be a routine desire and not one that rises to the level of an exceptional consideration. So we're not done with the public hearing yet, but I'm curious as to if my comments spur any additional questions of the applicant, or if the applicant wants to add anything based on what I've said.
Well, like I said, this is all new to me, so I'm having a problem, and please don't take it personally if I don't understand something and I'm trying to understand it. And like I said in my statement, that I used to believe that having I'm sorry, I'm really flustered. It's difficult for me because I thought we were supposed to be able to take care of our own properties. I thought that's something we stood up as Americans. And this is something that, you know, it's not hurting anybody, it's not causing any problems. I'm just waiting for it in case my mother needs it on the other side of when my stepfather dies. And I don't know why we're in such a rush to get rid of that mobile home. It's just a few months until my sister is available. It's just a few, probably a year that my mother will need it. And yet we're in a rush to get rid of it.
Can you help me understand why, other than she doesn't want to right now, something like that? Can you help me understand why she doesn't come back and live in it right now?
Her husband's dying, and she wants to make sure that she's there when he dies.
See, your husband never lived in the unit with her, is that right?
No. No.
So how long did your mother live in that unit?
She would only come for the summertime and occasionally for holidays.
So all of this time, that has not been her permanent residence after all.
I don't remember seeing anything about it being her permanent residence in any of the paperwork.
So under what condition were you permitted originally to have the Echo unit? Because from your prior testimony, my understanding was you were permitted to have the Echo, to establish and have the Echo unit in order for her to be there, but that's not the case because all along she hasn't been residing.
She for the past 13 years that she's been coming, like I said, she is somewhat demented. And it's a lot of work on her husband, and it's a lot of work on me, and it's a lot of work on my sisters. And so she would go, and when she'd get too flustered with her husband, she would come up to stay with me to get away from him for a while. And then when I get worn out because I got things going on with my daughter, she would go down to my sisters. And so she just went from family member to family member as, you know, needed.
One of the purposes of the Echo housing is to reduce the degree to which frail elderly homeowners have to choose between increasing isolation in their own homes and institutionalization in nursing homes.
Anybody else have any more questions for him? Nope. Okay.
I think we're good. Thank you.
Is there anyone else present that would like to speak in favor of the application? Do we have anyone online?
We have no members from the general public online at this time.
Thank you. Is there anyone present that would like to speak in opposition? If you'd like to come up to either podium, please state your name and your address and allow our attorney to swear you in.
My name is Harriet Fisk Pearson. I live directly across the street from Mr. Jackson.
Ma'am, if you will pull the mic a bit closer to you, please. If you could repeat your name and address, and then please allow our attorney to swear you in. Thank you.
My name is Harriet Fisk Pearson. I live across the street at 367 Bresh Drive.
Ms. Pearson, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I swear. I came here tonight not sure exactly what I was going to say. I knew what I felt. However, I do believe that everyone has a right, and I'm facing that in taking care of an elderly parent. However, 13 years ago, we were lied to, and that is why I'm here today. The truthfulness that we have been, he and I now have been sworn to, has not been upheld, and you have been misled. 13 years ago, this gentleman came to my house. I lived across the street. I've lived there for 30 years. He came across the street to my house, he told me that his mother was living in that trailer in Holly Hills, and that because he bought the house, he needed to place it on the property so that she could reside in close proximity to him, because he did not feel as though it was safe for her to live in Holly Hills alone. I found out after we approved that he get the placement of this, or this trailer was approved, we found out that in fact his mother was not in Holly Hills. He in fact lived in the trailer prior to moving across from us. There was never a residence in Delaware for the mother. Did she in fact ever come visiting? I don't know. Probably, I would assume so. But the fact that he came to us to place temporary housing for his mother because of her frail condition, the fact that she was unable to live independently in Holly Hills, not because of a disability, but because she, again, this is 13 years ago, she was early 60s, and he did not feel comfortable with her living there by himself, or by herself. So he knew at that time this was supposed to be a temporary residence. However, everything that was stated to us is not true. I live directly across from this trailer. I live directly across, and I can swear to you this man does not live in that house. Or in the trailer. His mother does not reside in that trailer for 13 years. And I'm not saying that I look at this trailer every day. I'm telling you there's no cars. He's not there. The house is dark day in, day out. I'm telling you no one lives there. Has she ever came to visit him on a holiday? Probably. Never seen her. The only ones that I've ever seen live in the trailer, he may go in and work on it at night, may stay there for a while, and may go back to the house. His daughter has come in with various friends that she has kept there. But his mother, I have never seen, Miss Ginger. She may be 77 now, but if this was 13 years ago, in 13 years, I've never seen her. Never seen the sister. They have not resided in that residence. Routinely, you might see his truck go into the driveway there to go to the garage. I'm not saying you won't. You'll see it maybe once a week. No one lives there. But Mr. Jackson made a really big faux pas when he came to my house one day. My husband, and in fact this gentleman, were working on an automobile of mine, and he stated that he was going to rent this SOB, that he was going to make money. There was no statement of a mom. There was no statement of needing to take care of mom. Honey, I take care of my father. I understand the needs and the demands of taking care of a frail elderly parent. But I'm telling you, she's not there. He came to my house. He stated that he was going to rent the trailer. That's what it was there for. It took him forever to get the skirting and all and get it, I guess, approved. I don't know, the occupancy permit, but that he was going to rent that trailer. And I believe that's what we're here for today. He stated about other trailers within the property. I live in a modular home across the street. There are a number of double wides and single family homes on that street. I do believe there are 2 single wides. Absolutely. It's not the placement of the trailer, it's the need and the misrepresentation that I have a problem with. He stated that he wanted to be there. He bought the property for seclusion and security, but what is he doing to us? He has lied, he has misled us and placed us in a position where we have to be here today. He says the house has 2 bedrooms. I've been there for 30 years. I've seen about 5 people in and out of that house. The man that lived there when I lived there had 5 children. It's a 2-story. Now, it may have had walls removed and therefore maybe 2 small bedrooms created a big one. I don't know. He was still there when his 16-year-old son died of cystic fibrosis, and there is a room just inside of the front entry that they turned into a bedroom. So it is possible if he wanted to bring his mother into that household. It's a large house. He could bring her into that household and provide for her care if she was in fact there. But for 13 years, I have never, not one time ever, seen this woman. He talked about what happens to the owner's rights. Well, neighbors have rights too, and I'm not asking him to remove anything. I'm asking him to be honest to you and tell you exactly what he's doing, because I don't feel as though he's done that. I know for a fact he didn't do it with us. He represented to us, again, that he was bringing his mother in, who never lived in that trailer.
So, Ms. Pearson, can you speak to any impact that unit has on your neighboring property or on you?
I don't care that the trailer's there. I don't care that there's a trailer there. I really don't. My impact is things like people who come out of that driveway routinely drive into my yard and do damage because of the angle of the driveway. That can be corrected. Little things. That stuff can be corrected. The placement of the way the drive, it comes out on an angle. So to swing in, you kind of swing into my property because it's a very narrow street. He talked about there being a tree line. I can only say that I can look in and look right to his front door. I mean, there may be trees there, but when you cut the bottom limbs off and the bottom limb's 30 foot high, obviously that doesn't create a barrier. If he can see that he thinks that I'm doing something in my yard that is illegal and come over to me, then obviously there's no barrier. As far as the economic impact to the applicant, he knew this was supposed to be a temporary fix when he created this issue. And again, 13 years, and she hasn't lived there. He even said that the mother's spouse controls her and keeps her in Florida. Well, if for 13 years she's been in Florida, then how she hasn't been here? And I just feel duped. I feel like he lied to us 13 years ago.
That's fine.
Yeah.
That's
Good. You can't reply to that. Sorry.
How am I supposed to respond?
Are there any questions for Ms. Pearson?
You can't respond to.
So somebody gets to say something
Sir,
with no
you
response?
have to sit down.
Yes, sir.
Hit your gavel.
I would like to invite all of you to come
Sir.
to my mobile home right
You
now.
or sir are out of order. Please be seated.
Are there any questions for Ms. Pearson?
Any questions?
No, sounds like there aren't.
I do have one. I'm sorry. So your sworn testimony is that his testimony with regard to the dwelling being occupied by a family member, and you're right across the street, and you
I am.
bear witness
Correct.
that person has not been living there for
No one
these
has resided
years.
there.
And it is primarily vacant. I'm just trying, and I don't want to put words in your mouth. I'm trying.
I absolutely am saying that the house is vacant. It has been vacant. At one point, a winter or two ago, the back door stayed open for months. It's vacant. It's been vacant since they placed it there. I'm not saying that somebody hasn't stayed there one night, the daughter, the friends, the whatever, but I'm telling you, it was not used. No, it's been vacant.
Thank you. So I have a question for staff, which I think I know the answer, but I definitely want to be sure for the record. That home cannot be there as a rental property without first having gone through the appropriate permitting through the county. Yes, no?
There is no approval process to place a second home for a rental.
But it's not considered an echo property as as that's what this meeting's about, or this application's about. It's not an Echo property if it's vacant or if it's being used as a rental.
If the home is not being used by a family member who is over the age of 62 and cannot live independently, then it does not qualify as an Echo unit.
Okay, that's absolutely what I want to have in the record. Thank you.
And I want
Go
to
ahead.
clear something, that you do have to have a permit for a second home on the property, correct? Just
You
not-
have to have
yes.
a permit in order to place the Echo unit, absolutely. You would have, or any type of accessory dwelling unit. We don't currently allow a second home on a property other than an approved Echo or ADU accessory
And
dwelling
the
unit.
Echo permit, if I'm remembering correctly, and it may have already been said, but the Echo permit has to be renewed yearly so that the county can identify that it is still occupied by the appropriate type of tenant.
Correct.
Okay.
Is there anyone else present that would like to speak in opposition? Please state your name and your address and allow our attorney to swear you in.
My name's Frank Marshall. I live the opposite of her and right next to the trailer.
Address, please, Mr. Marshall.
Oh, I'm sorry, 381 Burris Drive, right across the street from.
And you can raise the microphone a little bit to your face.
First of
And,
all,
sir,
I apologize. I
one-
didn't just come from the beach.
One second. Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Correct. Yes. I didn't come from the beach. I had a doctor's appointment in Christian Hospital, so I rushed to get here. Apologize. So I really only have some questions. Harriet hit on most everything. I think you had mentioned that someone comes out from the county and inspects and makes sure that things are done the way they're supposed to be from day one.
So we require that the owners submit a renewal application, well, not a renewal application, a recertification every year that the Echo unit is being occupied by a person who needs it. So they submit paperwork to us. We as staff do not visit the property in order to certify that.
Yeah, and Mr. Marshall, I just want to remind you, this is your opportunity to speak to the board.
Correct.
So share your thoughts
All right.
with the board regarding the appropriateness of the application and.
As Harriet said, that 13 years I haven't seen anybody. I raised a mother-in-law in my own property, right, not even 200 yards from his trailer, until she passed. So it's inconvenient. I understand it. I feel totally sorry for what he's going through. And I'm not here to make it any worse for him. But again, right from day one, the process did not go the way that a lot of us, pretty much everybody on the street that signed the okay to do this. We weren't told the whole story. It just seems like this is that somebody wanted to make money off of this. And he did mention the fact when we were working on a pickup truck that he was going to rent the property. I've never seen his mother. God forbid something happens to her. I wish the best. If she was over there, I'm a neighbor and I would have helped any way I could. I've tried to help him any way I can, and still will. But this is not the way this has been told that this is happening.
So, Mr. Marshall, to date, though, you haven't seen any evidence that the property's been rented to third parties?
No. There is a septic, and from what I understand, that the septic, 2 houses are sharing one septic system, and I presume that's why this had to go the way it did. But there's other properties on this road that other houses share separate septic systems. So I don't know if that's causing issues for the rest of us because there's a lot of trees dying in the area. I talked to someone, told us that septic is an issue for trees, and it's a low-lying area on his side of the road, on our side of the road. So I don't know what the burden will be for extra septic systems. But I do know I've not seen anyone in that house other than Mr. Anthony and his daughter.
Very good, thank you. Any questions, comments? Good, thank you.
Make sure I didn't have anything else to say. All right, thank you.
Is there anyone else present that would like to speak in opposition to the application? Ma'am, please state your name and address and allow our attorney to swear you in and adjust the mic as needed.
Elizabeth J. Caldwell. I don't know, I know.
Address,
Oh, I'm
please.
sorry, 315 Baroque Drive.
Ms. Caldwell, do you solemnly swear or affirm the testimony you give in the proceeding will be the truth, the whole truth, and nothing but the truth?
I do. My only concern is I don't want him to be able to rent it. It's a dead-end road where we live. And every now and then in the summertime, you have young kids coming in, hot riding, turning around, going, hey. If he rents it, I'm afraid we'll have a lot of that. And I don't like him, he's a mean man. He come across the road, over the ditch, to my fence, grabbed my dog by the ear and blew the dog whistle in her ear. And she's a house dog, so she doesn't bark. She doesn't bark. That's my only thing, I don't want it rented.
Not an opportunity for the public to ask questions, though. Well, we have restricted the speakers to one opportunity. I think we need to follow that rule for everyone.
Is there anyone else present that would like to speak in opposition? Please state your name and address and adjust the mic as needed.
I'm William L. Caldwell. That's my mom. And
Sir, if you could state your address too.
I'm trying to think of it. 115 Baruch Drive. Yeah. And there ain't nothing wrong with his heart.
Sir, Mr. Caldwell, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do, swear to God. Every time I see that man
Sir,
come down our road.
Sir, if I can just ask you, while you're speaking over here, while you're speaking, if you can just turn the volume down on your assisted listening, it's right there so it doesn't feedback.
There it goes. But every time I see him come down the road, he does try to wave. But I know what he done in the past to the dogs. If my dad was younger, he would have fixed it. But there's nothing wrong with his heart. Every time I pass him, he's got a kayak in the back of his truck. So if he can kayak, he can walk up 2 stories of steps. So I love y'all. That's all I got to say.
Thank you.
Is there anyone else present that would like to speak in opposition? If you please state your name and your address and allow our attorney to swear you in.
My name is Yvonne Marshall. I live at 381 Burris Drive.
Ms. Marshall, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. The one comment that I need to talk about.
Ma'am, if you could just pull the mic a bit closer. Sorry, it's hard to hear.
Okay, sorry. I have a soft voice too, so. When I looked on the county website at the information that's there about this property, it does not have Mr. Jackson's name as the owner. The names, I don't remember right now, but the first name is Grace. And I don't know if that's his mom or not, but so this property isn't even in his name, according to the county. And years ago, shortly after he put the trailer in, the county came out and gave that property its own address. And they gave that because they told us that it was a 911 thing and they had to have a specific address so that 911 would be there. So earlier we talked about this, it sounded like you were under the impression that this is one piece of property. But I don't know if you can be deeded and have it in the county in a different name, but I don't quite know how that works. He said that he's not creating any issues for any of us that live there, and that we can't see because of the tree line, and that's just not true. I can stand at my kitchen sink and see everything that's going on over there. And again, I don't have any objection to that, but it's just the fact that we don't quite hear the truth. It seems that, you know, we've been misled about some things. And he talked about manufactured houses, double wides and single wides. He, on his thing there, our house is directly across from the trailer. It is not a double wide. It used to be, but it is not a double wide now. I think that's all I have. Thank you.
Any questions?
I have one question. Sorry. So you live across the street, and to your knowledge, there has not been, the sister has not been living there.
I have never seen anybody except for his daughter and her friends in there and Mr. Jackson. And before that, they had a horse. I can't remember what the horse's name was, but that's the only living creature. Well, I shouldn't say that. He has goats too. But the mother nor the sister, I have never seen. And we're retired, so it's not like we're not there all the time, so.
Thank you.
You're welcome.
Is there anyone else present that would like to speak in opposition to the application? Seeing none, do we have anyone online?
Still no members from the general public online at this time.
With that, we will close the public hearing for application A2518 Jackson and Osbey.
Yep, we'll take a 5-minute break before we start the business meeting. All right, I think we have everyone back. Let's call roll, please.
Yes, sir. Mr. Gallo?
Here.
Mr. Carter?
Here.
Ms. Denny?
Here.
Ms. Hudson?
Here.
Mr. Cusick?
Here.
Thank you. That is 5 present.
Thank you. First item on agenda is approval of the business meeting minutes from June 18th, 2025. Need a motion and a second.
I make a motion that we approve the business notes from June meeting.
I second it.
Got a motion and a second. All in favor?
Aye.
Notice of decisions, approval of notice of decision from the June 18th, 2025 meeting. Need a motion and a second.
I make a motion that we approve the notices from the decision of the June 18th meeting. That would be.
I second that.
Motion and a second. All in favor?
Aye.
Aye.
Old business, none. New business. I think everyone's still here, so we'll start 825-16.
Yes, application A25-16 for Smyrna Rentals, seeking a variance from the rear setback of 25 feet to allow for the construction of a commercial building. They are looking to be 10 feet from the rear property line as opposed to 25.
Thank you. Any comments, discussion, motion?
This entire stretch to southbound 13 through that part of Smyrna down towards Garrison Lake is all BG. The adjacent property to this property, the construction company, their facilities sit right on the property line. The property directly across the street is also zoned commercial. It backs up to a State of Delaware golf course, which is not going anywhere. If it ever stops being a golf course, it'll be a park. So I don't see that there's any impact to any of the neighbors. So I would make a motion that we approve application A25-16 as requested.
I'll second that motion. I agree with your comments.
Got a motion and a second?
Mr. Gallo?
I vote in favor of the motion. I think it will be in keeping with the buildings in the area, and our failure to grant the variance might create a hardship on the ability of the owner to improve his business.
Thank you. Mr. Carter?
I vote in favor of my motion based on the reasons I stated.
Thank you. Ms. Denny?
I vote in favor. We have a business already existing there. It needs to expand. It's definitely in keeping with the character of what's going on around it. It's a good use for the property. And again, I find an exceptional practical difficulty in the fact that it kind of has been there and the business has grown, and I think it would be inappropriate for us to interfere with his expansion of his business. So yes.
Thank you. Ms. Hudson?
I'm going to vote in favor of A25-16 based off the public testimony that we heard tonight and the characteristics and the surrounding of the area. I believe it's in par with the area, and it's a commercial property, and it's not going to seriously negatively impact neighboring properties.
Thank you. Mr. Cusick?
Yeah, I vote in favor of the motion to approve application 825-16. I think the applicant, per his testimony, checked all the boxes here. All 4 criterias, doesn't impact any of the neighboring properties. It fits within the immediate vicinity, and then also the hardship for this applicant to be able to prove his business.
Thank you. That is 5 in favor.
The 5 in favor, application A25-16 is approved.
The next application is application A25-18 for Jackson and Osby. They are seeking a variance from the requirement that At least one occupant of an Echo unit must be over the age of 62.
Thank you. Any discussion, comments?
Well, just for discussion purposes, it appears to me from the testimony given this evening by the applicant as well as the other people who were here, that this property has not been being used appropriately as an Echo. That being said, I mean, it's allowed because it's an Echo, and if it's not being used as an Echo, then we should not be going outside of that and making a decision which is not in keeping with the code. To me, I don't even see an exceptional practical difficulty here in any way, shape, or form, although, that's not necessarily part of the list. So that's for discussion purposes.
I think the question is, it says, the different criteria, the issue is number 2, the plight of the owner is due to unique circumstances. And while unfortunate, illness is not a unique circumstance. It's something we all have to deal with. There are other options other than having a second home. You can adapt your home if you can't climb up the stairs. And they're difficult decisions. I'm not trying to minimize them, but I don't think the requirements were met in order to change and grant the variance.
And I agree with that.
Any other comments? Clarifications? Needed?
I'll make a motion for A2518. I'll make a motion to deny based off staff recommendation, the public testimony that we heard here tonight.
I'll second that motion. I believe that the testimony given this evening at this meeting does not meet the qualifications necessary in the code for this to be considered an Echo and remain there.
Motion and a second.
Mr. Gallo?
I vote in agreement with the motion. I don't believe that the requirements were met in order for us to grant a variance on this application.
Thank you. Mr. Carter?
I'll vote in favor of the motion based on the staff recommendation and testimony tonight.
Thank you. Ms. Denny?
I'm going to vote yes based on the staff recommendation and the fact that this is not being used as an Echo building as far as I'm concerned, in any way, shape, or form.
Thank you. Ms. Hudson?
I'm going to vote in favor of my motion.
Thank you. Mr. Cusick?
Yeah, I've been in favor of that motion, just based on staff recommendation and really the testimony given by both sides that this mobile home is not utilized correctly as an Echo unit, and as staff outlines that there is different alternatives that could be taken.
Thank you. That is 5 in favor of the motion.
With 5 in favor and motion, application 825-18 is denied.
Make a motion, we adjourn.
Second.
Motion second. Meeting is adjourned.
Aye.
Aye.
Favor? Aye.
Aye.